All right, that's the Axis management, but let's get ready now for the Revenue Secretary Shaktikanta Das and the Justice AP Shah. They will be making a statement. You've got images on your screens. We are given to understand that Justice AP Shah will also be making a statement. He's getting ready to speak now. Live visuals there on your screens.
So, this report has been submitted to the FM today. I can only say that the report is unanimous. It runs into 66 pages. I cannot discuss the contents of the report with you because it is for the government to decide whether to publish the report and when to publish it, and to accept or reject the report or to implement the report. That's really the prerogative of the government. So the government will examine the report and take appropriate decision. However, I can just tell you about the procedure that we followed. That after the reference was made, in fact the department issued a sort of call for responses, and we received a number of responses from the various industry organizations, associations like FICCI, CII, PhD Chamber of Commerce, ASSOCHAM, American Chamber of Commerce, ICAI, EBG, Indian Merchant Chambers, and several other, Vidhi Center of Commerce, Vidhi Center of Legal Policy, and some of these CA firms like KPMG, Deloitte, Ernst & Young, PwC. They appeared before us. Officials of the CBDT appeared before us. Then we also invited some leading advocates, Mr. Ganesh, Mr. Kaka, Mr. Kanbar, Mr. Arvind Datar, and several others. So we completed the hearing process on 13th of July, and now the report is submitted to the government. So what I can promise you only this, that once the report is published, if you have got any questions, any queries on the report, I am prepared to speak to you. My colleagues are also ready to speak to you.
And so by when does the government by when will the government have a view on the report, whether you accept it, reject it, however you want to take it? What's the time frame that you recommend?
No, I'll talk loudly, sir. No, we have just received the report. The report has been presented to the Finance Minister by the Chairman and the other two members of the committee who are present here. And the government will examine, consider the report and take a decision. Now, by which date, I cannot specify the date, but I can at this point of time say that the decision will be taken soon. I mean, the government will not sit over the report. The report will be gone through. We'll go through the report, and government will take a decision in this matter as soon as possible.
So are you planning to wait for the Supreme Court verdict, because there are some matters pending, even some foreign companies, group of foreign companies?
Supreme Court hearing is still about 10-11 days away, so we have time in between. We will go through the report, and the course of action which the government will follow with regard to the Supreme Court hearing on I think 4th of August can be decided in the next 10 days.
So how bulky is the report, if you can tell us?
It's 66 pages. It's not bulky.
Show the report.
You want me to show the report? Oh, okay. Sorry, this is the report. Yes, you can.
We get down the stuff.
Okay.
Also show that.
So just one question. One is sort of a
Just.
relief that has been given to foreign investors, because they were very, very concerned.
No. It's not giving any relief to any FIIs or any. This is a report on we examined the issues which arise out of inconsistent judgments of the AR. The first, there was a judgment in Tim Kaine, which was followed in Praxair, and then the Castleton, and there is one judgment in ZD. There are judgments of ITAT taking a very different view. So we examined the material. We looked into all aspects about the working of FIIs, the objective of 115 JB. We also gone into the international practices. So it takes a complete view of the holistic view of the matter, And then I think Mr. Das has indicated to you that a decision will be taken soon and we'll be able to see the report.
So the report, one by one.
Just to add to,
We'll come back.
sir, just to add to what you said, like, we will decide in 10 days, I think, is that?
No, I didn't say that decision will be taken in 10 days. That was with reference to the Supreme Court hearing on the 4th of August. I said what would be government's position in the Supreme Court, that, we have enough time for that.
Sir, one question. Question is, has the report recommended any legislative changes to the income tax?
No, that I do not wish to make any comment, because as I said earlier that I won't make any comment about the contents of the report. It will be inappropriate on my part to say anything about the report, because it has to for the government to publish the report, not for the committee.
Sir, my question is to the Revenue Secretary. Sir, will you make the report public first, or would you take the decision only then you would make the report public?
See, at the moment we are not making the report public. We have to first go through the report. The government will take a decision in the matter, and at that time probably the report will be made public. But again, a view will be taken in the matter. But first, the report has been submitted to the government. The government has to consider the report. So therefore, at the moment, the report is not being made public.
So any particular reason?
But in due course, it will definitely be a public document. I mean, in due course, it will definitely be placed in the public domain.
Sir, any reason why you are not making it public today, since it's just a view of the committee, it's not government view. So why can't you?
Or is it so that we are waiting for the Supreme Court thing also? After that, we'll take
No,
time.
I mean, I don't want to sort of go into reasons as to why it is not being made public. The point is a decision, a report has been submitted to the government. The government has to first take a decision. After that only the report will be made public.
Sir, one more question.
What is the sanctity of the report when it is for the Supreme Court to interpret the law?
What is the?
Sanctity of the report by a committee appointed by the executive when it is for the Supreme Court to interpret the law on a matter which is written.
You see, the report is very important. It is, I mean, if you talk of sanctity, government having appointed a committee would definitely give lot of weightage and lot of importance to the recommendations of the committee, because ultimately government has appointed the committee. So therefore it's very important. Recommendations are very important for government.
So one last question, has the committee specifically addressed as to how the existing demand should be pursued by the department?
No, not really. I should not be. Again, my answer is the same. I won't be able to comment on that. But that's that you have to see.
I think one thing, as Justice Shah has clarified, there are certain legal issues which the committee has examined. So, I mean, I take it that because I have not yet gone through the report, sir, but from what you said, the sense I get is that these are legal issues which the committee has examined and given its recommendations.
So you also wish to refer other matters also to the committee now?
Yeah, there will be further work now after this is over.
People also that earlier that you plan to give it more, some other issues which are tax issues which have created some kind of problem for the government, so do you wish to refer them?
There will be other issues which will be referred to the committee.
Thank you.
So,
Yeah.
what bearing will these recommendations have in the cases, particularly in the upcoming case and going forward, the other cases as well? In the sense, they will be essentially influence the government position?
No, there is one case in the Supreme Court, and I think recently some cases have been filed in the Bombay High Court. So therefore, we have time. We will go through the report and then
We
decide.
can understand the recommendation that this committee will have the bearing on the government's position in those cases as well.
You see, the recommendations of the committee are very important because the government ultimately has appointed the committee, so government will give definitely due importance and weightage to the recommendations of the committee. Now, what will be the outcome of the cases, how the cases are going to be dealt with? I told you, I think I don't want to repeat myself, we will take a view.
But sir,
I think
clearly
that's
you
what
will
you are-
wait for these cases, right? You will clearly wait for them before you actually arrive at a whatever decision.
No, I am not saying that. I mean, that is your question.
Just
but I am
consider
not
this.
saying-
I just want to ask you one thing. The report was submitted just half an hour back. It's very unfair. I mean, on your part to say that you tell us your decision. Any organization, whether it's the government or any organization.
See, we have to go through the report first.
Just to rephrase the question, sir, have you addressed, sir, just to rephrase the question, have you addressed every part of the terms of reference of the...
No, there is part of the reference was about the applicability of MAT to the FIS. This was the broad reference because this was the only issue which was at present which was referred to us, and we answered that reference.
Sir, what
I think that
issues could be referred?
Sorry?
By when?
What other issues could be referred?
Shortly.
What would those be, sir?
Huh?
What would
No, you will know once we notify.
Sir, with the recommendations that you've given, should foreign investors
The first question which I asked, even before I began the work, the first question was, I mean, what is the, even if you give a report, what would happen to it? And this was a question asked by one of you, before even I entered upon the reference. Anyway, thank you.
Okay, that's Justice AP Shah and the Revenue Secretary not saying very much, but let me just recap for the benefit of our viewers who have joined us. It's a 66-page report that Justice Shah panel has submitted to the Finance Minister today. The report's view is unanimous, and of course the Revenue Secretary there saying that the government will take a considered call. They give due importance and weightage as far as this report is concerned, and as far as that Supreme Court hearing in the Castleton matter is concerned, the Revenue Secretary suggesting that a government view is possible ahead of that Supreme Court hearing, which is on the 5th of August. He said that we have 10 to 12 days, and it is likely that if we need to take a call before that, we can do that. Joining us now is our panel of experts: Ketan Dalal, Senior Tax Partner at PwC, Siv with us, Mukesh Butani, Managing Partner of BMR Legal, and Dinesh Kanabar, the CEO of Dhruva Advisors, also with us. Gentlemen, appreciate you joining us. So here's what we know. Mukesh, let me start by asking you. Justice Shah saying that we've gone as per the terms of reference. He took us through the process of the consultation with various stakeholders. He said we've tried to attempt bringing in a holistic view to address the issue. He also indicated that they've tried to address several inconsistencies in the way that the legislation was used in previous cases. And of course, as he pointed out, he's not making the report public. It is the onus of the government, and the government is unlikely to make it public. At least still a considered call is taken. What do you make of what you've heard so far?
Well, I think the report is timed very well. Though the government keeps on saying that, the report is not binding on them, neither would the Supreme Court take anything by way of a binding nature of the report. But it's significant because it's just few days away from the time the Supreme Court will start the trial. Now, I think the big question here would be for the government would be that if the Shah Committee unequivocally holds that there is no case for levy of MAT on FIIs, then would the government accept their view and put an end to the litigation? So I think that is something that one needs to wait and see. So the government's official position is very clear, but I still feel that this is an opportunity to address the vexed issue and hence try and put an end to the debate, which is, in my view, an unnecessary debate, because I think a plain reading of the law makes it adequately clear that there is no case for levy of MAT, which is further fortified by the amendment brought about in the Finance
I'll come to the scenarios in just a second, Mukesh, but let me also bring in Dinesh Kanabar. Mr. Kanabar, as you were suggesting earlier this afternoon when you joined us, let's talk about the possibility of the government firming up its view on this matter before the Castleton hearing, which is on the 5th of August. And if I were to go back to the comments coming in from the Revenue Secretary, he's refusing to give a timeline, but he did suggest that it's not impossible for the government to make a considered call on this matter before the Supreme Court hearing. He said that it's 10 to 12 days away, and the government could make up its mind on this matter, and they will give due weightage to the recommendations made by the Shah panel. What does that tell you, sir? What does that indicate to you?
Two things. First, I must say I was a little bit disappointed when a question was put to Justice Shah to say what was the mandate of the committee, and he said it's restricted only to applicability of MAT on FIIs, because I think there's a broader question out there on applicability of MAT to foreign companies. And from what I took away from that press conference, it was that they have not addressed the larger question. That's one part. Second is, Again, the way
hang on, Mr. Kanabar, hang on. Let me get the others to come in, because that's an interesting point that you make, because while he did say that, yes, that was the terms of reference on the applicability of MAT on FIIs, he also then proceeded to say during the course of the conversation that the committee is trying to take a holistic view of the matter. How do we reconcile those two statements? We're trying to read between the lines here. Mukesh, would you agree with Dinesh Kanabar that perhaps the committee is only stuck to the terms of reference and narrowly looked at the issue of applicability of MAT on FIIs?
Well, yes, if we go by what he was saying, it sounded like they are going to look at the limited issue of FII on MAT, but my view is that they should look at the entire issue in a wholesome manner and address the vexed issue of levy of MAT on foreign companies, because I do not see any difference between an FII, whose characterization is that of a foreign company, and a foreign company itself. Well, it's again a technical argument, because if you get into this issue, what constitutes place of business in India, so on and so forth, then you really have to get into that issue. But I think it would be better if they address it in a wholesome manner.
That's what I'm saying. We're trying to reconcile the various statements that have come in, and we're clutching at straws here. Ketan Dalal, how would you read those two statements? One, Justice Shah saying that the terms of reference was the applicability of MAT on FIIs, and we've looked at that. But he also tried to say that we've tried to take a holistic view of addressing this issue. Would you agree with Mr. Kanabar, or do you think that perhaps we could see them address this vexed issue of whether MAT applies to foreign companies and not just FIIs?
Dinesh and Mukesh have said, Shireen, I think the issue of MAT on foreign companies, to my mind, is, as I said, broader. And if it does not apply to FIIs, FII is a subset of foreign companies. And if the conclusion is that it does not apply to FIIs, then obviously it does not apply to any... if it does not apply to FIIs, logically the same argument should apply to it not applying to any foreign company. But I really hope when he said holistic, I hope he meant it in that sense as opposed to looking at all the technical arguments.
Okay, that's the panel's view on the interesting point that Dinesh Kanabar brought up. Mr. Kanabar, back to you. That's on the issue of holistic or narrow as far as only FIIs are concerned. What was your other big takeaway from the straws that we're clutching at?
So Shireen, if I could just take a half a minute more on that issue. I would wish that it is axiomatic that merely because MAT does not apply to FIIs, it will not apply to all the other foreign companies. Because when I was deposing before the committee, there were a number of questions which came up, that there could be foreign companies which have a permanent establishment in India, but do not have a permanent establishment, where there is a deemed taxation. So it's a much broader issue. And as I said, I agree with both Ketan and Mukesh that one hopes that the committee has taken a larger view. But I was a bit disappointed to hear this comment, and I'm only hoping that it is not restricted to FIIs, which I suspect it is. Number one. Number two, to the issue, Shireen, on what the Revenue Secretary mentioned about the acceptance of the report. And again, the way I heard it was to say that in the next 10 days, there is a hearing before the Supreme Court on 4th of August in the case of Castleton. And probably the way I heard it, and I'm as you rightly said, we are clutching straws, but the way I took away was to say that the Revenue Secretary is saying that what stand will the government take before the Supreme Court might be guided by the recommendations of the committee.
Yeah.
Now,
that was my takeaway as well.
Correct. Now, that is slightly different from saying that the government will take its own stand and come out with a circular in 10 days. In fact, one of the reporters asked that question, and Justice Shah said, or rather the Revenue Secretary said, that's not what we mean. Meaning, all that the government is going to do is to say, here is a report, we will be guided by whatever the report says in taking a stand, which ultimately means only one other sort of small bit of a disappointment, that everything is going to be decided by the Supreme Court.
Okay, hang on, Mr. Kanabar, because again you're raising an interesting point. And Mukesh Butani, let me go back to you, because my conversation with the Finance Minister on this matter, and he was very clear. He said, let the courts decide, how this matter should finally end. Would you also think that we are likely to see the government not issue a clarificatory circular, the CBDT not issue a clarificatory circular, but the government present the recommendations of the Shah Panel and perhaps be guided in its argument in the Castleton matter on the 4th in the Supreme Court?
See, I think that the government, having taken the position that it has taken, would rather have the Supreme Court decide this matter. I hope I'm wrong. I mean, of course, a welcome issue would be, and assuming that the Shah Panel report is positive in favor of FIIs, a welcome decision would be for the government to simply issue a circular and be done with it. But I think a circular issued by the government carries far lesser weight than a clear verdict given by the Supreme Court. Because if there is a verdict given by the Supreme Court, that's the law itself. And as a trained lawyer himself, Mr. Jaitley would prefer for the latter.
Wouldn't it have strengthened, wouldn't it have then, if the recommendation is the most favorable scenario, if the Shah Panel's recommendation is indeed that MAT is not applicable to FIIs, if it is only to FIIs, and if there was a CBDT clarificatory circular, will it not then weigh in on the Supreme Court and put this matter to an end? Because if you're going to take a different position than in the Supreme Court without issuing the circular, won't it confuse things further?
Well, if the CBDT circular is issued in pursuance to the Shah Panel recommendation, the debate ends over there and the Supreme Court need not even examine this issue. The other aspect that you need to weigh in mind is that if by the time this report is made public or by the time the matter comes up before the Supreme Court and the government decides to hand it over to the Supreme Court obviously while hearing the matter will factor in the recommendations of the Shah Panel. So I think there are all possible scenarios, but to me it seems less unlikely that the government will issue a circular should the recommendations be positive.
Okay. Mr. Dalal, let me get a vote in from you as well on this issue of what you read and the likelihood of a clarificatory circular coming in or not.
You know, to my mind, I think they may come out with a circular. I don't think, obviously, the Revenue Secretary wanted to make that commitment on television immediately after the report has been issued. But to my mind, the issue of a circular and then a withdrawal of the litigation before both the High Court and the Supreme Court, that I think, before the Supreme Court, because the High Court, the burden has gone, so that's a different one. But the withdrawal before the Supreme Court and the issue of a circular, to my mind, is possibly a good way to go, and they may actually do it. I think the other broader issue is what happens if the Shah Committee is talking only of FIIs, and then what would be the content of the circular? Would the content go beyond the FIIs on the basis of a broader thing? Of course, maybe it may not go into the issue of a permanent establishment. At least the rest of the foreign companies, we do not have a permanent establishment. I certainly hope so, and of course, as Dinesh said, we're clutching at straws currently, so we'll have to obviously wait and see.
We certainly are clutching at straws at this point in time. Our colleague, as you can see visuals on your screen, Sapna Das, trying very hard to try and elicit some sort of a comment there from Justice Shah, but not very successful. But Mr. Kanabar, back to you. One of the other comments that came in from Justice Shah was the panel tried to look at the inconsistencies that have arrived at the application of the legislation in previous cases. He mentioned Timken, for instance. How would you read that?
Sorry, if I could, Shirin, just make one comment on what was discussed earlier on the Supreme Court circular versus whatever.
Sure.
And whilst I do agree with what Mukesh mentioned that a Supreme Court judgment is the law of the land, I think where we are still heading for is that what relevance is then the committee's report? If the Supreme Court is going to decide, sure, committee can give a recommendation, Supreme Court may be looking at that recommendation, but when a Supreme Court decides a matter, it decides the law, not on the basis of any committee's recommendation. And if we are ultimately looking at Supreme Court deciding and all that we are talking is what should be the government stand, it's irrelevant what is the government stand because Supreme Court will read the law and decide. And the only disappointment I have is that we are ultimately going to leave everything to Supreme Court. We had this one welcome change in the case of Vodafone where a High Court judgment was accepted, did not go to the Supreme Court. And I would actually wish that here the government can quickly come out with a circular on the basis of the recommendation of the AP Shah committee, because that will show that the government does not want everything to land up at the apex court. Coming to your question about this holistic review, and again, maybe part of this I state on the basis of what
and the inconsistencies.
Correct. So what has happened? There are two parts to the inconsistency. First is the judgments which have come really have not been one way. they have looked at multiple. So there are different things which have weighed in on the mind. Take for example the tribunal judgment of Bombay in the context of Bank of Tokyo Mitsubishi, where where a foreign company had a permanent establishment, it was held that it is not liable to MAT at all. From there on, a situation to say that if there is no permanent establishment, only then MAT will not apply. To a third situation that it applies to everybody. So different judgments have come in, and the last of the judgments which came in, which is what gave rise to this whole the Castleton judgment. If you see the Castleton judgment, what happened there was, first and foremost, the department did not even argue the matter of MAT. It was the judge ruling on the matter, coming back to say it does not matter whether or not this issue is litigated by the department. We have to decide the matter on merits. Number one. Number two, there were certain items in the section itself, 150. Even I don't not being very technical here, where the judge read into to say maybe the law intended to apply, and then again there are inconsistencies within the law. For example, that the MAT provisions were introduced thereafter, section 115AB, which gave a lower rate of tax. 2 FIIs came in and all of that stuff. So there are a number of inconsistencies within the law. There are a number of inconsistencies with the judgments which have come, and possibly the report will address this in an appropriate manner.
Yeah. Mukesh, let me get your comments in, because this was perhaps the only clear signal that Justice Shah gave, that there was inconsistencies in the use of the legislation or the applicability of the legislation, as well as inconsistencies in the judgments in previous cases as well. How would you read that, and would you agree with what Mr. Kanabar has just said?
I don't know if there was any inconsistency. I think if, a bogey is being made out of the Castleton decision that the government could not clarify the law because Castleton was pending before the Supreme Court, as Dinesh just said it earlier, the question of levy of MAT was not even there, and Castleton is not even an FII. I think the government could have simply gone and said that the amendment that they have brought about in the Finance Act of 2015 is clarificatory in nature. Because the fact is that the FII law has been in the statute since 1993. And since 1993, no assessing officer has raised the issue of MAT in any of the assessments. So I think this is the amendment brought the confusion, fortified the stand of the department to say, since the amendment is prospective in nature, retrospectively MAT should apply. And thereafter this whole issue came up about, what did the AAR write in the Timken decision? Does the FII have a place of business in India or not? So the officers in Mumbai simply went ahead and said that the Timken decision, which says no MAT should apply if a foreign company doesn't have a place of business in India, holds good. However, these FIIs have a place of business in India. Now, whether an FII has a place of business in India or not is an issue of fact, not an issue of law. So I think this whole debate on levy of MAT on FII has been muddled up. It could have been handled very differently, and we could have easily avoided this controversy, in my view.
Oh, I don't think anyone is going to dispute that or argue or quibble with you on that. But Ketan Dalal, coming on that comment that came in from Justice AP Shah, that the report has tried to sort out the inconsistencies on the applicability of the legislation as well as the inconsistencies in past judgments.
Yeah, so I think, again, this is a point, again, this can get a little technical, but as Dinesh mentioned, what happened is that after the MAT provisions came, there was a lower rate of tax for FIIs. So again, as Mukesh was mentioning, I don't think these kind of issues were considered by the tax department, or rather the provision was considered by the tax department as something which was applicable to any foreign company. Castleton, incidentally, was not an FII. Even that came only in 2012, and for many, many years it was not considered. So I think those are the kind of inconsistencies. If I were to give one more example of an inconsistency, under the provisions of a section called 150 on withholding tax on interest, there is a 5% withholding that came last year. Now, if MAT was supposed to apply to a foreign company, then how would the 5% have any meaning at all? It can't.
Right.
And the reason is simple, because nobody even envisaged that it was there. So I think the intent, Shireen, all along has been absolutely clear that, much broader than FIIs, it was never supposed to apply to any foreign company. There were a few decisions which, of course, were there because of some small ambiguity in language. And I think the answer would be to clarify that ambiguity and bring the ambiguity, remove it and bring the law in line with the clear intent as opposed to fighting it in a court of law.
Yeah, gentlemen, just hang in there. I've got my colleague Sapna Das, who's been trying her very best to get something more from Justice AP Shah as well as the Revenue Secretary. Sapna, anything more that you have for us beyond what we heard in that press conference?
Not really, Shireen. The government is very, very tight-lipped about it as of now. So there is basically absolutely no kind of a signal as to whether the report is in favor of the tax department or it's in favor of the taxpayer. But one thing is definite, and this is basically, I take off from what Justice Shah has said in the press conference, that the reference has been to issue of MAT levy or FIIs. So I'm not very sure whether they are actually looking at the broader definition of foreign companies.
You've hit the nail on the head, and this is the disappointment that Dinesh Kanabar was also sharing with us. Mr. Kanabar, Sapna's feeling exactly the same way, sir. You want to weigh in on that?
No, as I said, basically, it's just, if I may say so, here we are looking at foreign investment. We are trying to give certainty around law. We are talking about ease of doing business. And here on one simple issue, as we have been all talking, there is a clarification. And instead of that clarification clarifying, it is raising a controversy, and we are dragging the controversy. We have now a committee. The committee has a partial mandate. Will continue with the litigation. And it's sometimes you feel sad that if you have such a wonderful committee, as I said, Justice Shah understands the subject really very well. He went into the depth of the subject. I wish the mandate would have been larger, and I wish the report would have been on a much broader macro issue rather than just leave it to FIIs.
Well, we hope that that's not the case, and we hope that we're taking, perhaps we are reading what Justice Shah had to say narrowly in response to the terms of reference, but that was the terms of the reference to the committee. Whether they've gone beyond that or not, at this point in time, the suggestion seems to be that they haven't. Well, as I said, we don't have the fine print, we don't have the 66-page report, we don't have any details on the recommendations that have come in from the panel. But Sapna, very quickly, what were your other key takeaways there, specifically from both Justice Shah as well as the Revenue Secretary?
Well, the sense I also got was, though of course it was not said, neither Revenue Secretary nor Justice Shah indicated anything on that front. But the sense we have also got is what we have been reporting, since yesterday, that probably they'll also wait for some of the court cases to reach a certain stage. I mean, this is a sense I have gathered. Now, it's like a chicken and egg situation. Then if you really want to do that, then why do you have the panels, why do you ask a report from such a learned panel? No answers to that. But I think the government is just going to take it, step by step. They're playing it very, very safe. The other thing also that the Revenue Secretary did indicate was that they plan to act on it soon. So now, how soon this is going to be, we just have to wait. But he has clearly indicated on the Castleton case coming up.
Yeah, he did seem to suggest that it's not impossible for the government to take a call on this before the Castleton matter, which is in the Supreme Court on the 4th. So he did suggest that there's 10 to 12 days, and it's not impossible for the government to arrive at a decision before that. But gentlemen, let me get wrap-up comments from you, and I'm extending an invitation to all of you to join us on camera. We've caught you on the phone as this was breaking news, but I'm extending an invitation to all of you to join us on camera this evening. So let me start with you, Mr. Kanabar, wrap-up comments, and then to you, Mr. Dalal.
Really delighted that at least we have some movement forward, and we'll wait to see the report. I think the reason why the fine print is not released is so that you can have some more discussion on the airtime. So I think there's a conspiracy to keep you occupied there and to keep us all occupied there. And then we'll wait to see what's there in the report.
All right. Final word to you, Mr. Dalal.
Yeah, as I said, I hope it is much broader, but I think more importantly, even if it is not much broader than the FII part, I really wish the government would come out with a circular and just put this matter to rest. We have many other things to deal with, and uncertainty being caused on these kind of matters to foreign investors is certainly not doing us any good at all, neither for the capital market nor otherwise. So I really think that a circular withdrawal of the cases is most important and on a broader basis than just FII. All
right, gentlemen, appreciate you joining us here with your take on on reading between the lines at what got said at that press conference, both Justice Shah's comments and the Revenue Secretary's comments. Thank you very much for joining us here. Mukesh Butani, Ketan Dalal and Dinesh Kanabar, and of course Sapna Das for reporting live from North Block for us. Well, we've done a lot talking about the likelihood of what could happen. We don't know what the recommendations are. And of course live footage playing out on your screens there from Finance Ministry, where Justice AP Shah has submitted his report to the Finance Minister. We were expecting a quick comment from the Finance Minister as well, but I am given to understand that the Finance Minister is unlikely to address the issue. Sapna, final comment from you?
Well, Shireen, my sense is still what we have been reporting so far, that there could be, glad tidings on the way for a large section of FIIs. There are two ways to look at it. One is, sweeping recommendation coming in the form of saying that MAT is applicable only to domestic companies, or the other way of looking at it would be that, it is, not applicable on those FIIs who don't have a permanent establishment here in India or do not have a, physical physical presence, so to speak. That itself, would actually, put the matter to rest in a major manner, because the reference is basically looking at the issue of MAT levy on FIIs prior to April 2015, and in fact, even the Finance Ministry's press release was very clear about the terms of reference. So, most likely it is going to be in that direction. And as far as the clarificatory circular is concerned, that will only be a matter of process, because that is something that is understood, that once the government takes a decision, point is that when will they take the decision? Once the government takes the decision, then the clarificatory circular has to follow. And the assessment orders, the demand notices or the assessment notices which have been issued so far, they will stand closed. So that is a set procedure, and everybody is aware about it. I mean, this is what my expectation is. Just have to wait for it.
Yes. Well, we let you work the phones. Appreciate you joining us here. Of course, that's the latest there as far as that much-awaited report is concerned. Cannot disclose the contents. Just very few indications there coming in from Justice AP Shah, saying that the report is 66 pages. It's unanimous. It's taken a holistic view, and it's tried to address the inconsistencies arising out of the applicability of the legislation and past judgments. Well, it's also been a big earnings day. We've had Reliance Industries announce its numbers. We've had Axis come out with its numbers.